In some meetings with a new client, I see that the issues in dispute are narrow and not particularly complex, and communication between my client and their spouse remains constructive and relatively conciliatory. In these cases, after giving them advice about the parameters of resolution that the law provides and permits, I suggest to the client that they firstly discuss settlement options privately with their spouse, without any formal intervention by me. In an encouraging number of cases, the client returns sometime later to inform me that agreement has been reached, and they just seek my assistance to formally document the agreement. In these cases, it is cheaper, quicker, and more productive to represent yourself in reaching an agreement. You can represent yourself in any family law matter, but when a matter has high levels of conflict and disagreement, complexity, or risk issues, it's not advisable to do so. While self-representation in these cases can save you money in the short term, it will often cost you in other ways. Being entirely objective in negotiating or preparing for court hearings is very difficult at the best of times. Your ability to carry out such tasks will be considerably handicapped if you are dealing with a controlling or an emotionally abusive spouse. A litigious environment with your spouse can be emotionally triggering for you. Emotional reactions like anger, avoidance, and defensiveness that you may have developed during the relationship to cope with certain behaviours of your spouse may be inappropriate representing yourself in either negotiations or court litigation. It may jeopardise the very outcomes you see financially for yourself and the arrangements for your children. The other difficulty is to obtain the appropriate level of legal knowledge and insight to effectively navigate and apply what is voluminous pages of legal rules, legislation, principles and cases that will be required and relevant in determining a case. Behaviours, actions, attitudes and feelings that you may think are important in your case may not be relevant at all in deciding your case and may in fact damage your case. Without the appropriate knowledge, training and experience, it is very difficult to know the assets that you should be seeking by way of property settlement, whether you should seek a maintenance order and if so, how much, and what are the best arrangements for your children in the short and long term. Family lawyers have knowledge of taxation consequences of dividing assets in a property settlement. Not knowing these consequences before a court makes an order can be financially detrimental to you. Preparing a case for a mediation or court is very time consuming. For a lawyer, weeks of work is done to prepare for just one day in court or a mediation. In preparing your case with a lawyer, you'll be surprised how unemotional but precise, structured and factually detailed court documents are required to be. Strict time limits apply in filing your court documents. If you get it wrong, you may be penalised by having to pay your spouse's legal costs. It is strongly recommended that you retain a family lawyer who is an accredited specialist to represent you in your family law matter. Please contact me or one of my team to discuss representing you in your family law matter.